How is child support determined in Illinois? Well, it is a easy yet complex topic, and it's all based upon the situations for you. So let's start first. It's based upon net income of the parties. But before we get there, there's this one little magical number that some people are aware of, and that's 146. Now, what is 146? That's the number of overnights you need to have in a year for child support to be lessened if you're the non-custodial parent. In other words, a lot of times people are fighting for 40% of overnights even before they come into my office, and they don't even understand why. So let's back that up and say, why do people care about the number of overnights? When Illinois went to the income shares model, the number of overnights became the factor in deciding who pays child support and how much. Now, there's always exceptions to every rule, so when you're watching this, don't just assume that it 100% applies every time. But what we need to do is we need to figure out what's the overnight schedule, what's the income, we figure out the percentage of income between the parents, and then we apply it to a statutory formula. All right, so let's go and give an example here. Let's assume, for sake of discussion, one parent has the majority of parenting time, and they have a combined net income of $10,000. The parent that has the majority of overnights is parent A, and they make $4,000 per month. Parent B has $6,000 per month. So in this situation, parent B has 60% of the net income. So all we need to do is we go in, we apply that formula, we go down a spreadsheet, figure out what that net income is, and then we apply 60% to whatever numbers in that spreadsheet. Say, for example, in that spreadsheet, it comes out where it's $1,000 a month. 60% of 1,000 is $600 a month. In this situation, parent B would pay $600 a month to parent A. Now, I know it can be a little overwhelming because there's spreadsheets and formulas and calculations, but if you have a good attorney, they can actually show you the formulas, how they apply in your situation. And a lot of times people will argue, they think that the other side makes a little bit more or a little bit less. And I tell people all the time, it doesn't usually make that big of a difference. So having an attorney that can walk you through the formulas, show you how they're calculated, and we can even play with the numbers a little bit. Hey, let's assume they made a little bit more. Let's assume they made a little bit less. You'll see what that impact is on your child support. So you can ultimately decide, is it worth fighting over that extra little amount here or there? Modification of child support can take place anytime there's a substantial change in circumstance. Anytime? Yes, anytime. A lot of times people will say, well, we were just in court last month. I said, well, is there been a new substantial change in circumstances? Well, yes. My spouse or ex-spouse just got a new promotion, and they're now making significantly more money. Depending upon how much that is, yes, you may be able to go back to court and have a modification. So typically you're looking at 10, 20%, give or take, somewhere in that area. It's not a hard and fast rule where it's always this percentage or that percentage. But what's the change? If it's a few bucks here or there, no, that's not worth going back to court. In situations like that, what I always recommend tell people is, look, if we have a regular W-2 wage earner on both sides, stick with the formulas and only go back to court if there's a major difference. One thing I recommend is if you think that your spouse's income is going to change, that you make sure in your divorce papers, you get some sort of requirement that they share their income with you on an annual basis. This way you can look at their W-2s, their tax returns, and see if they had a change in income. If there's a significant change, you can file a motion, go back to court. Now, on the flip side, let's say that you go into court, you just get your child support modified after getting a raise, and a month later, your company downsizes and you lose your job. You must file a motion to modify. Now, this is one of the biggest mistakes I see people make all the time, is they lose their income or their income drops, and they have a conversation with their ex and just tell them this without modifying it. It's one of the biggest mistakes I see people make. You must file a motion to modify child support with the court. The parties cannot modify child support on their own. You actually can modify parenting time, believe it or not. If you want to switch weekends, you don't have to go back to the court. But if you want to change how much child support you have to pay, you must get the court's approval. So what are child support arrears and how do they impact your situation? Well, Arrears are when somebody has a child support order and they don't make the payments timely. In other words, if you have a child support order of $1,000 a month and you pay $800, well, now you've got a deficit of $200. In other words, arrears of $200. What happens is sometimes these arrears can pile up over time, and that's where problems can take place. If this piles up too high, it can lead to suspension of driver's license. It can lead to jail time. It can lead to a lot of problems and concerns. On top of that, arrears gets interest on it. You have to pay 9% simple interest on top of whatever that was. Simple interest meaning it's not compounding against you like a credit card would, but every month you're not paying, another 9% is being added on top of that. So it's really, really important that you get those taken care of as soon as possible, because waiting too long only makes things worse. How can you ensure that the other parent follows the child support orders? Well, the short answer is you can't. Because guess what? You only control you. You don't get to control what the other parent does or doesn't do. Now, there are some things that you can do to try and make that happen. In Illinois, we have a withholding order, which is done across every state. That means if they have a regular employer, you can send off a withholding order to their payroll department. They are then required to withhold that money and send it per the terms of that order. So in Illinois, we have a thing called the state disbursement unit. So typically what we like to do is we get the order set up. It comes from their paycheck, goes right to the Illinois State Disbursement Unit, and then you get the money. Now, that works great when they have a traditional employer. What do you do when they're self-employed or when they don't have a traditional employer? Maybe they're an independent contractor, they are a 1099 worker. In those situations, it's very, very difficult to enforce it other than making them pay per the terms. If they don't pay, you can file a petition for rule to show cause with the court and ultimately hold them in contempt. Now, you can do that through our office, you can do it through the Attorney General's office, or you can even do it on your own. But the bottom line is you don't get to control what they do with their money. With child support, it's important that you have a team in your corner that can explain how child support is impacted based upon your unique situation. At our office, we'd be honored to help you figure out what makes sense for you going forward.